Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started today, I've got to give you a legal disclaimer. This podcast isn't legal advice. The Florida Bar Association says I've got to say it, so now I've said it. But nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance company world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, I know that you've purchased a disability insurance policy through your employer or on your own to provide you and your family with peace of mind if you became disabled. That's what my dad did, and ultimately he had to apply for his disability insurance benefits because of leukemia. So I've been where you're at. Unfortunately, I will tell you that disability carriers will rarely pay Parkinson's disease cases in the early stages of PD. We've done an episode earlier on Parkinson's disease, but this episode is going to provide you with some new and different information as the disease and its relationship to disability claims, like many other illnesses, is ever changing. And I'm going to talk about three things today. One, what you need to know about Parkinson's disease and steps one of the three evaluation process that the disability carriers will use in Parkinson's disease cases. And I'm going to then talk about steps 4 through 6 of the evaluation process used by disability carriers in every PD case. And then lastly, I'm going to talk about the impact of stress on your Parkinson's long-term disability claim. So I'm going to pull back the curtain for you in this episode and explain to you the 6 steps that disability carriers will use in evaluating every PD claim. Got it? All right. Let's take a break for a moment before we get started.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Ready to get started? What you need to know about the first 3 steps that disability carriers will use in the evaluation process to determine whether or not they're going to pay your PD claim. Parkinson's is a gradual but progressive disorder of the central nervous system, and it affects your movement. In the early stages, it may start with barely noticeable tremors in just one hand, little or no facial expression, or your arms may not swing when you work. Now, we know that PD can be difficult to diagnose in early stages because you've traveled down this diagnosis journey. But that will work to the advantage of disability carriers who are always looking for reasons to deny benefits. Now, of course, as your condition progresses, unfortunately, your symptoms are going to worsen. But the progression will vary from person to person. And disability carriers rarely consider how these symptoms progress or how your symptoms have progressed. So let's talk about the evaluation process that's used by disability carriers in every PD case. Number 1, they're going to ask, is your Parkinson's disease a pre-existing condition? Now, every disability policy or plan has a pre-existing condition clause. This clause says if you become disabled within a certain period of time after you become covered under the policy, your disability is going to be considered a pre-existing condition. This is called a look-back period. And if you get treatment for your disabling PD during this period of time, the carrier legally does not have to pay your benefits. So it's crucial that you understand how this pre-existing condition clause works, because you can't pick the wrong date to become disabled. If you do, I can't fix it, and no other ERISA disability attorneys can be able to fix it. So they're going to look at when did this policy become effective, and what's the look-back period, 60 days, 90 days, and whether or not you got treatment in that period of time. If so, they'll use that as a legal basis to deny your claim. And if we don't have this look back issue, then you're great. But here's the step that is the next step, step 2. Is there objective medical evidence that's the basis of the PD diagnosis? Now, many disability policies or plans require that there be objective medical evidence of the diagnosis, and preferably that diagnosis coming from a PD specialist. So it is crucial, in my view, that you give an accurate history of your symptoms at every visit. What are those symptoms that I would be looking for and that the disability carrier plan is looking for? Uncontrolled tremors, muscle stiffness, an inability to make voluntary movements, impaired posture or balance, the loss of automatic movements, including blinking or smiling, changes in your speech, changes in your handwriting, difficulty concentrating, cognitive issues, and depression. The disability carrier is going to look closely at your medical records. They want to make sure that there's a history of your symptoms, but they're also going to look for the progression of the history of those symptoms. And they're going to look at the diagnostic findings and the exam findings to ask whether or not there is consistency with a diagnosis of Parkinson's. Now, of course, they're also going to be looking for objective medical testing, such as MRIs, to document the presence of PD. But of course, in early stages, you don't always see that. So remember that. Now, what's step 3? Your doctor may have given you restrictions and limitations. And at step 3, the question is there objective evidence, medical evidence, that's the basis for the restrictions and limitations assigned by your doctor? So the carrier says, okay, well, we've got a diagnosis, who cares? Because unless they have restrictions and limitations, it doesn't matter, because the test is whether or not they're unable to do the material and substantial duties of their occupation. You'll see all over claims denials and court decisions that a diagnosis alone is not sufficient to obligate the disability carrier to pay benefits. So the question becomes, what are the restrictions and limitations? Your doctor is going to be asked to complete some forms called attending physician statement forms, explaining and outlining your restrictions and limitations. Unfortunately, there's no uniform APS form. Every carrier has their own, but no carrier has one that's specific to any disease, much less PD. These forms are designed on purpose to have your doctor say that you can work in some capacity, and certainly if you're at the any occupation stage, that you can do sedentary work. Why? Because if you can do sedentary work, you may not be disabled under the terms of your policy when we get to paying any occupation benefits. Now, the APS form is going to ask your physician to explain the objective basis of the restrictions and limitations. That can be really tough based on the nature and progression of PD symptoms, the fact that you have good days and bad days, or your reaction to various medications. I think one of the ways to help your physicians complete the APS form is to explain at each visit what your symptoms are and how those symptoms impacted your ability to function. And of course, I always supplement that APS form with a Social Security Disability Residual PD form, because that's the form that asks for the right questions. Got it? All right. Now you understand the first 2 and 3 reasons why disability carriers will play the denial game in looking at a PD claim. Let's take a break.